Welcome back to Organize, the business law breakdown. I'm your host, Seth C. Oranburg, and today we're diving in to one of the most controversial areas of contract law, fraud and misrepresentation. Contracts are built on trust. So what happens when that trust is broken by lies or deceit? What's the line between sales talk and outright fraud? That's what we're going to explore. Imagine agreeing to buy a piece of property, only to find out that the seller hid major problems with the house, maybe by painting over a huge crack in the foundation to make it invisible. Can you get out of the deal? What if the sale was as is? Or worse, what if you've already signed the contract and transferred the money? Do you have the power of rescission? Today, we're breaking down when fraud and misrepresentation can invalidate agreements, allowing you to escape deals built on deception. In our last episode, we looked at how mistakes can sometimes undo contracts. Now we're taking it one step further to examine what happens when one party isn't just mistaken, but is actively deceived or is pressured by the other party into a contract that they did not otherwise want. We'll cover key cases like one where a widow was tricked into buying thousands of dollars worth of dance lessons, and another where a home sale didn't exactly mention the termite problem. We'll also explore how courts handle claims of fraud, duress, and undue influence. So if you've ever wondered what happens when fraud or deceit is involved in making a deal, or even where that line between mere sales talk and fraudulent action is drawn, stay tuned. We're about to uncover the secrets and lies that can make contracts disappear. Now that we've set the stage, let's break down the key concepts surrounding fraud, misrepresentation, duress, and undue influence in contract law. These are all situations where the fairness of a contract comes into question because one party didn't have all the facts or was improperly pressured into the deal. Just quick step back into policy land. Why do we enforce contracts? Because people have made voluntary agreements to give something in exchange for something else. This is the heart of contract law. It's about private choice. It's about individual freedom. And that freedom doesn't exist when there's fraud, misrepresentation, duress, or undue influence. So we're really at the boundaries of when we can make the assumptions we typically do about free action and capacity to engage in a deal intended to benefit oneself when we have these conditions. So let's start with fraud. Fraud occurs when one party knowingly makes a false statement with the intent to deceive the other party, and that deception leads the other party to enter into the contract. So there's reliance on the fraud. Misrepresentation, on the other hand, can either be intentional or unintentional. It's any false statement that induces the party to agree to the contract. Again, we have the same idea of reliance or inducement and some proximate cause between the statement and the agreement. The key difference here is intent. Fraud requires an intent to deceive and is very similar or sometimes referred to as the same as intentional misrepresentation, although it has a connotation of even more sinister behavior. And misrepresentation could simply be unintentional, an honest mistake. But just because you were honestly mistaken doesn't mean the deal goes through. Courts generally won't enforce contracts based on fraud, especially when the misrepresentation is about a material fact. A material fact is something that is significant enough to affect the decision to enter into a contract. You lie on purpose, the other person can probably rescind the deal. Duress and undue influence involve pressure or coercion rather than lies. We're talking about some type of physical or, in some cases, economic pressure, although economic coercion is kind of a funny idea that's a little hard to pin down. Duress occurs when a party is forced into a contract under threats of harm or unlawful pressure. So duress examples include terrible situations, the proverbial gun to your head kind of situation, or a threat of an ex-husband to take the ex-wife's children away, or something like that. If someone signs a contract because they've been threatened with physical harm if they don't, like pay us more money or you wear the cement shoes mafia, that contract is voidable, at least in courts of law, because it wasn't entered into voluntarily, which disrupts the basic idea of what contracts are meant to do. Undue influence happens when one party takes advantage of their position of power to unfairly persuade them into a contract. Now, this rarely involves force, but it could involve an elderly person who is hospitalized and their life is in the hands of their nephew, who insists on a update to the will or a transfer of ownership of the Cadillac in order to subtly encourage the maintenance of that care of that person. That's an unfair relationship. We need to see, however, in undue influence cases, a close and trusting relationship, like this one, a caregiver and an elderly parent, but also maybe a rabbi and a member of the synagogue, a priest and a parishioner, potentially a senator and someone he represents, a judge and someone in the jurisdiction. We need to see a power dynamic based on the relationship. Otherwise, we don't have undue influence cases. A case that highlights misrepresentation is Banta, where a widow was pressured to buy expensive dance lessons based on a false promise that I guess she would learn to dance the cha-cha and find the young man of her dreams in her widowhood. Now, she was potentially easily duped, but she was duped. And when she realized the deception, she sued. And the court ruled that the misrepresentation voided the contract. We'll dive deeper in the next segment. Another case that showcases fraud is Swinton, like Swindler, where termites were hidden from view during the sale of a house. The buyer wasn't told about the infestation, and the court had to decide whether the seller's silence amounted to fraud. Because actually, not speaking is typically not a statement, but turns out there are some cases where you have an obligation to speak. The common theme in all these situations is that contracts must be entered into freely and based on accurate information. If one party is tricked, coerced, or pressured into an agreement, courts will often step in to protect the wronged party and invalidate the contract. Now that we've covered the key concepts, let's break down Sciester v. Banta, a classic case of misrepresentation. This is one of those cases where a court stepped in to protect a vulnerable party who was tricked into making a deal. In this 1965 case, Miss Sciester, a recently widowed woman in her 60s, was persuaded to purchase thousands of dollars worth of ballroom dance lessons from Arthur Murray Dance Studio. Over the course of several years, the studio's people flattered her, made false promises about her progress, and convinced her she would become a professional dancer. By the end, Miss Sciester had spent nearly $30,000 in 1965 money on lessons she would not realistically benefit from, at least not in the sense that she was ever going pro. When Miss Sciester finally realized she had been duped, she sued the dance studio for fraud and misrepresentation, and the court found in her favor. The court ruled the studio's misrepresentations about her potential as a dancer were material to the contract and had influenced her decision to keep purchasing lessons. The court invalidated the contract and awarded her damages. Now, I find this case a little surprising because shouldn't she have known better? Perhaps it's a 1965 example of how things were back then, but this case is still on the books. And Sciester shows us that when one party makes false statements or even over-exaggerations that induce the other party to enter into a contract, that contract can be rescinded. And I think Miss Sciester's perceived vulnerability due to the perceptions of a person of that age and gender at that time in history, combined with the dance studio's deceptive tactics, convinced the court that the contract wasn't made in good faith. Would the same results play out today? You be the judge. But in the book, Sciester highlights how misrepresentation can unravel a contract. Now, what if the deception isn't so obvious? Let's discuss a what if that tests your understanding of when a misrepresentation is enough. Imagine you're buying a used car, not from a dealership, but from a private party. Saw it in Auto Trader, and the seller tells you the car is in perfect condition with no history of accidents. You don't get the Carfax, and Carfax cries. You purchase the car based on the information, but later find out that it's been in multiple accidents and the seller knew about it. Can you void the contract based on the seller's misrepresentation? Yeah, probably. The seller's false statement about the car's history is a material misrepresentation. It seems intentional here. It was something they knew about and chose to make a statement that was intended to influence your decision to buy the car. And since the seller knowingly misled you, this seems to amount to a fraudulent misrepresentation, and you could rescind the contract or claim damages. Now, a court that was critical of you, or if you were a more empowered person who bought cars routinely, maybe might say that it was on you for not buying the Carfax report. I do think that's unlikely, but not impossible that you didn't do your diligence and the risk was on you. Again, here, the fact that the seller had actual knowledge and made a false statement intentionally is what matters. Let's take it up a notch. What if the seller didn't lie, but failed to mention the car had been in an accident? Does silence about a material fact count as fraud? It depends. In some cases, silence can amount to fraud. But that usually is when the seller has some kind of duty to disclose important information that affects the value of the contract. And those duties usually arise from some kind of special relationship, like you'd find in an agency relationship. If the accidents were significant enough that a reasonable buyer would want to know about them, courts could consider the seller's failure to disclose as fraudulent. But if the buyer never asked, and the seller had no legal obligation to disclose the information, it might not count as fraud. In fact, you don't have to say everything about a product you're selling. You don't have to go on and on about all its problems to avoid being fraudulent. In general, you can keep silent unless you're asked. But don't lie. Here's one more what if. What if the car is perfectly fine, but you bought it because the seller promised its value would increase over time? Like you bought a Tesla Model X for $50,000 and he assured you that this car holds its value better than any other car and will be collectible in 10 years. And unfortunately, it's worth half that now. Can you claim fraud based on the seller's prediction? Nope. You really can't get a fraud claim on a prediction about this future because predictions about the future aren't facts. And we need to have a statement about a fact, which is untrue. Statements about future events, like whether a car will increase in value, are generally considered opinions or predictions. Fraud and misrepresentation usually have to be based on statements of fact that are false at the time the contract is made. Since predicting future value is inherently speculative, unless the seller made a factual misrepresentation about the car's current condition, it's unlikely you could void the contract. So whether you can void a contract based on misrepresentation depends on whether false statements are about material facts. Courts are more likely to step in when a misrepresentation goes to the heart of the agreement, and especially when one party is intentionally deceiving the other. Now let's break down another case, Swinton versus Wentzville Savings Bank, where the seller's silence about termites raised questions about fraud. The Swinton case involved a seller's silence about a material issue, and it raises important questions about when failing to disclose information, when staying silent, can amount to fraud. In this case, Mr. Swinton purchased a house from the Wentzville Savings Bank. After the purchase, Swinton discovered the house was infested with termites. Now, the seller, the bank, knew this, but didn't disclose it. Swinton sued, arguing that the seller's failure to mention the termite problem amounted to fraud. The question before the court was whether silence, when the seller knows something important but doesn't share it, could be considered fraudulent misrepresentation. The court ultimately ruled in favor of the bank, finding that silence alone doesn't amount to fraud. The court reasoned that unless there's a duty to disclose certain information, failing to mention a defect like termites isn't the same as making a false statement. In this case, there was no duty to inform Swinton about the termites, so the contract remained enforceable. There was no special relationship between these parties requiring that sort of trust and confidence. Swinton, frankly, should have done the inspection. Shows that not every omission of information is fraudulent. Courts are more likely to find fraud where one party actively makes a false statement, or where there's a specific duty to disclose important facts. In the absence of such a duty, silence doesn't automatically void a contract, even if it results in an unfair deal. So, while fraud can sometimes be based in silence, the law draws a line between deception, affirmative deception, with statements, and withholding information. Let's look at how misrepresentation and fraud appear in pop culture. One of my favorite examples comes from the movie Catch Me If You Can, where Frank Abagnale, played by Leonardo DiCaprio, spends years deceiving people by pretending to be everything from a pilot to a doctor. His entire life is built on fraud, using false identities, forging checks, and tricking others into believing he's something he's not. You Catch Me If You Can, we see how deception can be the foundation of deals and relationships, much like in contract law. While Abagnale's actions are clearly illegal and far beyond simple misrepresentation, the film highlights the idea that trust, whether in contracts or personal relationships, quickly unravels when built on lies. Another Leonardo DiCaprio movie is Wolf of Wall Street, and in this form, Jordan Belfort, played again by Leonardo DiCaprio, tricks investors into buying worthless stocks by making false promises about the value of those investments. His fraudulent actions eventually lead to his downfall and to his criminal indictment, and shows us that lies in business deals rarely stay hidden forever. Although, frankly, in these cases, sometimes the money's gone by the time a remedy can be imposed. Belfort's story is a classic case of fraud, where false statements about material facts, like the present value of stocks, lead to big financial losses. And importantly, Belfort had a relationship of trust and confidence. So here is one of those cases where he actually had a duty of candor above and beyond what normal people have. And he went below that. From Catch Me If You Can to The Wolf of Wall Street, Leonardo DiCaprio shows that fraud and misrepresentation can create temporary success, but lead to disastrous consequences. In the world of contract law, these principles hold true. Contracts built on lies are often doomed to fail. Let's recap what we've covered today. We started by exploring the concepts of fraud and misrepresentation in contract law. Whether through active deceit or failure to disclose material facts, when one party is tricked into an agreement, the law often steps in to undo the contract. In our Break It Down segment, we discussed cases like Banta, where a dance studio's false promise led to a vulnerable party spending thousands of dollars. We also looked at Swinton, where the seller's silence about termites wasn't enough to void the contract because the court found no duty to disclose. These cases highlight how fraud can unravel a contract and whether silence may or may not be considered fraud. The key takeaway is not all falsehoods or omissions lead to the undoing of a contract. Fraud requires an intentional misrepresentation of a material fact, while unintentional misrepresentations can still be enough to invalidate an agreement. Courts are more likely to act when there's a duty to disclose certain facts, such as because there's a special relationship between the party, and especially if the facts are crucial to the deal. Have you ever entered into a deal only to find out later that the other party wasn't entirely truthful? I'd love to hear your stories or any questions you have about fraud and misrepresentation in contracts. Share them with me, and you might hear your story discussed in a future episode. Don't forget to subscribe, leave a review, and share this podcast with anyone interested in learning more about the intricacies of business law. This episode concludes our conversation on whether contracts are forms. Going forward, our podcast will focus on understanding contract terms, and then we'll deal with what happens when those terms aren't followed. So, stay with me and we'll learn more about reading contracts and working with them. I'm Seth C. Oranburg, and I thank you for exploring fraud and misrepresentation in contracts with me today. I hope you found the conversation insightful and thought-provoking. And remember, keep your agreement strong and your argument stronger.